All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time scheduled for oral argument in our case number CR12-0684, State versus Hollingsworth. Each side has been allocated 20 minutes for oral argument. If the appellant desires to leave any time for rebuttal, you can do so, but you have to manage your own time. And there is a clock in the podium that indicates how much time you have left of the 20 minutes. So that to help to assist you, you should be aware that we've read the briefs, we've conferenced this, we've talked about the issues, so we're relatively familiar with the facts and the issues in the case. If you don't use up your 20 minutes and don't have anything to say, feel free to sit down. When you approach the podium, since we're recording this matter, please clearly state your name and who you're representing. And remember, if you ever step away from the podium, we'll lose you on the record. We could lose you on the recording, so just keep that in mind. So with that, am I pronouncing her Gundacker?
That's correct, Your Honor.
Okay.
Good morning, Your Honors. Robert Gundacker for the appellant Curtis Hollingsworth. In this fact-intensive case, the way I have it organized is there are 7 factors that lead to the inevitable conclusion that egregious prosecutorial misconduct occurred and that the trial court abused its discretion in not ruling so and banning the second trial under the Double Jeopardy Clause. First, we have an experienced prosecutor. Second, that experienced prosecutor had an attitude that demonstrated a feeling of entitlement to a conviction by misconduct because of his belief that the ends justified the means. Third,
Well, how does the attitude reveal itself in the record?
okay,
I know when my daughter has an attitude, for example, okay? But it wouldn't show up on the record.
okay. Your Honor, I think there are numerous facts that do show that. First, when the out-of-court identification procedure came to light through the cross-examination of the trial defense attorney, and then Mr. Young started back on redirect examination, though his defense later was a disingenuous, I forgot the key fact of the case, he never said, oh, that's right, despite the defense attorney's opening statement that had emphasized these facts. He instead underscored them and had the victim answer a leading question of whether or not she had any doubt that she knew for a fact that the assailant was the defendant in the case. And then I think the second primary fact, although I believe there are numerous facts, is on oral argument when he called his error a technicality and stating that the defendant had no right to an acquittal because of a technical mistake, never seeing or ever conceding anything other than his contention that he had simply forgotten and therefore it was a mistake. And it's our position that his contention that it was a mistake is not true and, in point of fact, was disingenuous for numerous facts I've stated in my brief. And if you want me to go further on that issue, Your Honor, I can certainly do that. The third factor in this case is that this experienced prosecutor committed grave misconduct by manufacturing an in-court identification in a case where identification was the forefront issue and facilitated having a victim now 100% sure of the perpetrator's face and 100% sure of the perpetrator's shirt, where previously identification was merely circumstantial. The fourth is that experienced prosecutor then demonstrated his reckless disregard to a mistrial or a reversal by failing to disclose the manufactured evidence, and in fact went further by the way in which he presented it was by not mentioning the fact that he was going to have an in-court identification in his opening statement, and just did it on direct, and that was the first time the defense had an opportunity to even know that that was going to be an issue. The fifth factor is that when he was caught, he disingenuously, as I've said, tried to convince the court that this was a mistake with the excuse that he forgot the victim couldn't identify the perpetrator in a case where that was the primary issue and underscored by the defense's opening statement. Sixth factor is that he never once ever in the Deserold hearing or the Poole hearing or at any time ever demonstrated any remorse. He simply stated that he had made a mistake. The seventh is that this prosecutor then demonstrated his commitment to misconduct in the second trial, because as the court understands and the pleadings show, the result of the ruling on the Deserold hearing was that now the prosecution wasn't going to be able to use the victim's identification, and so he had to change his strategy to now use the defendant's statements to law enforcement, whereas he had clearly stated in the first trial he wasn't going to, and then turned around, and the primary point of misconduct in the second trial was the abuse of those statements he now had to use, because in his opinion these statements put the defendant at the scene, the general scene of the incident. He had to use that, but then he wanted to discredit those, and those are the Doyle issues that I've set forth in my motion. But it's interesting to note that he was put in that position because of his misconduct in the first trial, and then turned around and committed misconduct as to those very statements in the second trial. And one of the other issues, although I don't think it's as primary as the Doyle issue, is when he characterized in the second trial why they had not done a one-on-one lineup or any identification with the victim and the suspect. He was disingenuous with that. He tried to create the impression that the reason that was not done was because of the strength of the identification information, not because of its weakness. So then he commits misconduct with the very key information that was the subject of the misconduct in the first trial. So those things show that, I think circumstantially, that this was a matter of design. This was a prosecutor who was committed to a conviction no matter what he had to do to get it. He didn't learn his lesson. And then that's the very prosecutor that we're supposed to take his subjective word for his intentions and his actions prior to trial, at 2 separate meetings with the victim, prior to trial and the failure to ever disclose the information, his behavior about why he presented the case, the identification information at trial, the way in which he did, and the fact that he never demonstrated remorse.
Aren't we reviewing this as de novo, but giving some deference to the trial court's finding of fact and its ruling?
Judge, that is correct. I think that the case law says that it is a de novo standard, but it's a de novo standard in such a fact-intensive case that I would concede the court's point there. That's why I took the time I did in my brief to lay out the trial court's error in its findings of facts and its error in its pool focus by only focusing on a small part of the pretrial misconduct, never conceding that the failure to disclose had anything to do with it, the way in which he presented it at trial had anything to do with it, the fact that he would have had to forget for over a month had anything to do with it. I think that the trial court in this fact-intensive case did not accurately recall the facts, and accurately use the facts.
Well, so your argument is that there are other objective facts that were either ignored or the court glossed over, or accepted the lawyer's statement as to his memory with respect to the issue.
That's correct, Your Honor, and I think the things I quoted from the Poole case really show that the primary emphasis that the trial court is supposed to give in determining the mens rea under Poole, whether there's indifference or intent, is the objective facts. And the record clearly shows that the judge did not primarily focus on the objective facts. The judge primarily, or possibly even solely, focused on the subjective defenses of this prosecutor.
Was the evil here that the prosecutor showed the victim the photograph, or was it how he used the results of that discussion at trial?
Well, I think it is both, Your Honor. He should have known. He had conceded he knew what the Deserol case was all about. He's an experienced prosecutor. Should have known this is an identification case. This victim can't identify the defendant. I should be careful and only bring the picture of the shirt to this meeting if I'm going to bring it at all. And then he should have disclosed it. If he's truthful that he just made a mistake because he forgot, he should have then disclosed.
But the prejudice could have been avoided. Even if he had shown the victim the photograph, the prejudice could have been avoided by a different line of questioning at the first trial, yes?
Yes, and different preparation of the victim, Your Honor.
As I look at the transcript, though, he goes on this whole line of questioning that leads up to the identification, and defense counsel's not objecting.
That's correct. The first point at which defense counsel objects is when the victim answers the question calling for identification. And I think he was caught by surprise.
It's fairly obvious that he's leading up to that for a number of questions beforehand. I'm just wondering on the first prong of Poole whether the mistrial was avoidable in the first case. Had the judge taken appropriate action, or had the defense raised a more timely objection?
Your Honor, that's an interesting question. I think while we are critical of the trial court's view and use of the facts, it seems from the record that the trial court was caught by surprise. And of course, the trial judge doesn't really understand the issues like the trial counsel does. But everyone was caught by surprise that this would even occur, which I think underscores the fact that he didn't mention it in his opening statement. And while I think it's clear Monday morning quarterbacking it, that the questions are designed to lead up to it, he's laying foundational questions, it's logical for us to conclude that what trial counsel is doing is assuming that what the prosecutor is doing is leading up to her identifying a picture of the shirt, for example, or of the license plate number, not to the actual face. Or is he similar? Now looking at the defendant in the courtroom today, is his beer belly similar to what you said you saw? Things of that matter. That's what defense counsel would have been expecting the prosecutor to do, not to say that she was going to identify the face. Your Honor, I think that what we're asking for is a dismissal because the second trial should have been barred under the double jeopardy clause. And as the court knows, the procedural history of this case, there was a special action filed, but the Poole hearing was scheduled a week prior to the second trial, and there was no time to do that special action. And that second trial should have never occurred. And the evils underlying the double jeopardy clause certainly came about. A second trial went on. The prosecutor had, while the law says it's okay, he had the chance to change his strategy and then commit further misconduct. But even if this court does not believe that the second trial should have been barred, this case should at least be remanded for a rehearing on the Poole issues, Your Honors. Because first, when the Poole hearing occurred, the trial court did not place the prosecutor under oath when he volunteered to testify. he was not placed under oath, nor was he questioned. He gave a narrative, and that was an improper hearing because he was just allowed to go off and he was never placed under oath. And this is a case where the veracity of this very prosecutor was in question.
Was that objected to?
It was objected to, yes. I think strenuously objected to, and a large offer of proof was made because of how important that was. The second thing is that it's our position that the trial court erred in numerous ways under the law as to Poole. The trial court seems to, over and over again, blur the distinction between intent and indifference. There's a footnote in my brief where I quote the trial court. While, defense counsel tries to demean intent, I think that has a strong position in this case. And then every time there's a ruling, including the minute entries, there's a blurring of intent and indifference. And I don't think this court can be confident that that trial court allowed for the standard of indifference in this case. The second thing the trial court did not do was we can't tell if the trial court used the request for a mistrial as a factor against the defense in ruling on the Poole motion. That was argued by by the prosecutor and then basically mimicked by the trial court. That, well, you asked for the mistrial, so that's a factor against you. And it clearly is not. So we can't tell by the record whether that standard was properly applied by the trial court in ruling on the Poole issue. As I've already stated, we do not have proper factual findings by the trial judge. We do not have a proper focus on the totality of the facts that constituted the misconduct that we then ask, was there intent or indifference as to? So we don't have a clear record, or at least we argue that there's a clear record that that standard was misapplied. And then we don't have a record that ensures us that the trial court emphasized the objective facts as primary instead of the subjective contentions of this prosecutor. So for all of those reasons, we do not have a trustworthy ruling on the Poole issue, and if this court is not going to say that there was a clear Poole violation and the second trial should have been barred, it at least should be sent back for refindings under the Poole and instructing the trial court to make its ruling under the proper standard and under the proper set of facts, Your Honors.
Then what happens? Okay, we remanded for a Poole hearing. There's a Poole hearing. The court makes its findings of fact. Then what?
Well, it would be our contention that when the
Then
trial
you
court,
take a special action?
assuming the trial court does not rule for the defense at that point,
Okay.
then I think, yes, then we'd be back on special action. Depending, however, on how the trial court rules and what the trial court says and what evidence would come out at such a hearing. If there were contended errors, then I think, yes, we would be back on special action. That's true, Your Honor.
Well, because I'm just trying to figure out, if A, then B, but what about C? So, okay.
In essence, you're saying that if it was remanded for another Poole hearing, it would avoid the at least the implicit idea that we were making findings of fact.
If this court felt that that's the position it was put in, even though it's a unique situation with de novo review, then it certainly would solve that dilemma.
It's de novo review of the court's application of law to fact, but when the court finds that the prosecutor was credible, setting aside for a moment the lack of sworn testimony, that's not de novo, is it?
Well, I think it strikes me from...
there, the court was. Aren't we supposed to defer to the court's findings of credibility, absent some clear error?
Yeah, I think as an abstract principle of legal analysis, I think it does become a combination, and there's just not case law with a case like this where it's so fact intensive. Usually the facts are not even in dispute and the inferences are not in dispute. The question is whether it's harmless or whether it was on purpose or things like that. But if that's what the court feels like, if you're feeling like what you're doing is re-reviewing the trial court's findings of facts, then I would just reiterate, those findings of fact are objectively an abuse of discretion, because we know what the trial court said. We can go back to the transcript of the court's statements at the end on its ruling on the pool hearing and the minute entry, and we know what facts the trial court was relying on, and we know that the trial court did not consider the totality of the facts. And as I was reviewing that transcript, I saw that the trial court stated, well, under the totality of the circumstances, I'm denying your motion. And my reaction to that emotionally was, no, you're not ruling on the totality of the circumstances. You are ruling on a very limited snippet of the totality of the misconduct. And I think this court should have really no problem in finding that that version of the facts that she applied to her version of the law was an abuse of discretion. So I think you don't even have to worry about that. But assuming you do, I think we can send it back.
Let's say we were prepared to go there had there been sworn testimony. Does the absence of sworn testimony so infect the proceedings that whatever our view of the facts, it might be improper to reach a final conclusion?
Well, Judge, it would be our position that it is, but I would concede that's a close question. But a close question in a much broader context where we have a trial court that took the subjective statements of that prosecutor at face value without really analyzing the objective facts and coming to the conclusion we think is correct, that he's being disingenuous.
Isn't that the point? That if it hadn't been a narrative and the person had to testify, the prosecutor had to testify and be subject to cross-examination, the trial judge might have reached a different result.
It's possible. Why do we have an oath? It puts the witness in a different emotional position.
That would avoid us trying to say, well, without ever considering the credibility of someone, we're just looking at the objective factors, but we don't know how we would feel. We're not fact finders.
That's correct, Your Honor.
Well,
I think I'm out of time.
thank you, counsel.
Thank you.
Good morning, Assistant Attorney Michael O'Toole, appearing for the state of Arizona. There are two kind of factual matters I want to talk about before I start talking about the first issue. First, in his briefing, appellant asserts that the prosecutor brought only one picture to the interview with the victim, and that's the picture of the defendant with the shirt on. And he didn't bring the picture of just the shirt, and that's just false. I mean, the evidence indicates the prosecutor brought all the exhibits. He was introduced at trial to the meeting with the victim, and that's demonstrated by the prosecutor's testimony, which the trial court credited.
But that's not a helpful fact for you, is it? I mean, if he had the picture of just the shirt.
Well, I think it is a helpful fact as opposed to just bringing that one picture, bringing everything he had, because he's meeting with the victim and going to go, okay, we're going to trial. Here's a picture of the car, et cetera, and this just kind of came up when the victim mentioned something to the fact, I'll never forget his face.
Well, but he had the opportunity to do it right.
He did.
And even though he had all the materials necessary to do it right, he did it wrong.
He blew it.
So the fact that he had that second picture,
well, that
seems to me weighs in favor of the defense.
It doesn't, because if he just bought that one picture, that kind of suggests he bought that one picture for that one purpose. And by bringing all the exhibits, it kind of just makes it show that it's just a meeting with the victim to go over the trial exhibits. And he wasn't thinking.
A two-edged sword, though. I mean, because on the other hand, he could have said, well, I remember there wasn't a Deserol hearing, she couldn't identify him, and suddenly she's telling me she won't forget his face. Why don't I figure out what's going on here and just...
Well, absolutely, he should...
Show her the shirt.
He should have done that. He didn't, but that's kind of my first big point about the objective evidence supporting the trial court's decision is the fact this was really not an ID case at all. First of all, you look at the notice of defense is filed by the defense. There's diminished capacity.
It's become an ID case. It may not have been.
But I'm trying to put the court in the prosecutor's position way back when.
Okay.
So we have this notice of defense. He raises diminished capacity, insanity, mistake of fact, lack of criminal intent. He doesn't check the box or the mark for mistaken identity. There's a whole...
No, but even though the state feels pretty good about its case on identity, isn't that an element?
It really wasn't in this case because we had all the evidence showing identity, aside from the actual facial identification. There was really no question that this was the person, and defendant himself admitted.
This is to make it an identification case right there at trial by surprise.
Well, that just goes to show that it wasn't intentional. Just kind of, the fact that it was an identification case kind of just made it
I don't
a
see
situation
how you
where.
ask questions by accident at trial.
Well, he asked the question, and he wanted to identify him because she had stated at the hearing that she could identify. I'll never forget his face, is what she said. And despite the prior statement, if you look at the attachments to the motion to dismiss, there's like a police report where the victim says the victim couldn't provide any identifying information about his face. That itself does not indicate she couldn't identify him. And then there's an interview attached, and there's like 50 pages, and right in the middle there's one statement. So given the defendant's statements that he was there in the area and had some kind of contact with the victim, given the fact that she described the car, described the shirt, described him generally, and got the license plate, I mean, it's just not an identification case. If you look at the defendant's opening statement in the first trial, he's not saying this is a mistaken identity at all. He's saying the victim's making this up for some reason, and she had some kind of plot to convict this guy for some unknown reason.
But it's not the defendant's burden to define the issues for the state. It's the state's burden to prove its case. And if the state felt so good about the case on the identification issue, it's hard for me to believe that it was accidental, that it then pursued not just one question, not a blurt, but a whole line of questions, including foundation, to bring this out in a way that the state, I think you're conceding, knew was totally unnecessary.
If the prosecutor was aware of this, I think the prosecutor would have said, well, what am I doing? I don't think he was aware of it. He just kind of, something that just kind of happened. It was a small part of the case.
Middle of trial?
I'm sorry?
In the middle of trial?
In the first witness?
Yeah, but I mean, you're at trial.
Right.
And the prosecutor is laying foundation, a whole line of questioning leading to what is normally a pretty critical and dramatic moment in a criminal trial. And is your argument that he just didn't realize he was doing it? It's so reflexive.
He didn't realize that there was a prior statement, one statement in an interview that he had read a while back that she said she couldn't identify his face. As the defense attorney admitted during the Poole hearing, this case had more paperwork than a first-degree murder case. There was like 18 or 20 different disclosures. There's video, you know, it just was not out on his radar. If it was, I mean, such an obvious mistake in retrospect, why in the world would he do something this obvious and cause a mistrial when, in fact, identity was not an issue? I mean,
I might ask you the same thing.
well, it was a mistake. That's the only reasonable explanation for that. And a mistake under Poole is not enough. A mistake under Oregon versus Kennedy is not enough. Even a gross mistake is not enough. A mistake is a mistake. He made a big mistake, but that's all it was. And you have to look at the circumstances of the case. The case law basically indicates one of the big factors, and Poole is a prime example of this, is if a case is going badly and the prosecutor does something, intentionally engages in misconduct, he's trying to throw the case so he gets a new trial. Here, this case had just started. There was no problems with the case. The state had a very, very strong case, and it wasn't going south. He had no reason, no motive whatsoever to do this. So that's a very strong factor. That's actually a factor cited by this court in State versus Corvigan, 2002, Arizona 493, a 2002 case. And basically that case said the state's case had not proceeded to a point where the state would benefit from some kind of misconduct or some kind of overreaching or something. And then we have State versus Trenny 200 Arizona 383 from 2001, and basically saying the state's case was not so weak that this would be a reason why the prosecutor do this.
Doesn't the state always benefit, though, when there's a powerful, dramatic moment of the in-court identification in front of the jury? And that's a pretty big selling point for the jury, isn't it?
Your Honor, I agree this is a big mistake. It really is, and it's stupid in retrospect. The prosecutor was experienced.
Well, that's not really the point I'm making. The point I'm making is the state did have something to gain from taking this to the limit, because there is that certain element of trial drama of having the victim point out the defendant in court. The jury kind of expects it. It seems lacking if the state doesn't get it. And so they got it. And why isn't that a motive right there? Because it's,
the repercussions of that are so great, because if he was aware of this, he would know that it's a big mistake. It would cause a mistrial and possibly bar a new trial. Why would he risk that when he doesn't need it at all? And those cases basically talk about that exact point. And also the concurrence in Oregon versus Kennedy talks about this.
If we applied that reasoning, then almost any misconduct could be justified by that bootstrapping. Because
No,
we'd say, why would I ever commit misconduct if I know I could lose the case?
Well, I think in those cases like Poole, you have a situation where the case was going south from the beginning. He made the wrong charges. He had introduced the wrong evidence. The defendant was getting the better of him on cross-examination, and he basically, in the middle of trial, threatened to, recharge him. So that was a case that was going south, and he just kind of made mistake after mistake after mistake, as opposed to this case is one mistake, a big mistake, but it was really one mistake, isolated mistake, as opposed to the situation in Powell. In other cases, basically have not followed Powell's when they basically find one mistake. Another factor in support of the trial court's ruling, the factual finding, is that in this case, the prosecutor resisted a mistrial, which indicates he didn't want a mistrial. He wasn't trying to go for a mistrial. And that's supported by the concurrence in Powell in Oregon versus Kennedy as a factor why retrial was not barred. And if we look at the situation down below too, even the trial defense counsel didn't really seem to be that troubled by this initially. When the question was asked, can you identify him, there was no objection right away. There's about another page before when he introduces the photograph that he objects. And then later on, he didn't file a motion that day or alleged misconduct that day. Later on, he filed a motion to preclude identification of the victim, strike that, and then an alternative for dismissal. So even the defense attorney initially did not see this as some type of misconduct. And at the Poole hearing too, the prosecutor or the defense counsel was saying how much he respected the prosecutor. So the parties below, including the trial court, did not see this as a matter of intentional misconduct. And the bottom line, this is a finding of fact this court defers to under Lamar and Kevorkian. And there is, I think, 6 or 7 different reasons why the court's finding is supportable. One, identity was not really an issue. Second, there was so much information about this case, and that one statement was kind of buried in information. Should have known, but it was not a big thing part of this case. Third, the state's case was not in trouble. The mistake was so obvious that if he would have realized that, he would never have done it. As opposing counsel says he wants to get away with this, but that would effectively involve a conspiracy between him and the victim here immediately just told the truth and explained what happened. There's no conspiracy. Again, resist the mistrial.
Saying the victim's at fault.
Well, if we were to believe that this was some kind of intentional mistake and that he tried to cover it up or something, I think that's what the defense is basically saying. The prosecutor
hoped not to
get
made a disclosure before trial. That would have mitigated any.
It would have.
Cover up.
I agree that should happen.
So he showed her the wrong picture, then he didn't disclose, then he laid foundation, and then he used it. That's a lot of mistakes to commit by accident in a row, isn't it?
I'm not really sure how much foundation was really there. I think basically
I've got the transcript
Okay, well,
here.
I think
there's
it's
a fair amount.
I just recall as one question, can you identify him?
No, there's a good page here.
Well, it just makes no sense that he would do this intentionally, frankly. That's the bottom line. Why would he do this intentionally? You say to gain an advantage?
Why would he make 4 mistakes in a row? I mean, one mistake is one thing, but showing her the wrong photograph, not disclosing, preparing for trial, laying foundation and asking a question, that's a lot of mistake upon mistake.
That's all based on the same thing, the fact that he wasn't aware that she previously said that she could not see his face. So it's a continuing mistake, I think, as opposed to separate mistakes.
But what about the narrative issue? Wouldn't this have been better, all of the alleged either mistakes or intent, been better explored by the trial court if the prosecutor had been forced to testify and subject to cross-examination?
He was cross-examined. Frankly, I don't. If he was under oath, I'm not sure if that was objected to. He did testify. He was cross-examined. He testified in a narrative, and then opposing counsel got a chance to ask him questions.
Okay.
And kind of leads me a little detour into one of the last issues, which is.
Do you think the oath is important? Because we've had this argument before in this court recently, where prosecutors have said, I'm a prosecutor. Everything I do is effectively under oath because I'm under special ethical obligations, so it's just not that important. And we've rejected that argument. Do you consider the oath important in a Poole hearing?
I'm not sure if that's a requirement or not, and here I don't think there was an objection. The prosecutor, I think, was on the stand testifying.
But you have a prosecutor who is defending his honor
Yeah.
effectively and is allowed to do so without taking the oath. That seems extraordinary to me.
Well, I think both defense counsel and prosecutors oftentimes make offers of proof and avowals in a trial court, and that's accepted in most situations.
Well,
Here,
the difference is it's an avowal of evidence as opposed to your integrity is being impugned, which could have severe consequences. If the trial judge or anyone else thinks it's appropriate that you so misbehave that you should be disciplined by the state bar.
well, here, again, I don't recall if there was an objection to him testifying with not being under oath. So I don't think it's certainly fundamental error. If he's testified, he's subject to cross-examination, and the trial court can hear the demeanor and
Well,
make it
if the victim were on the stand and people just forgot to place her under oath, that'd be a problem, right? If the state's witness in its case in chief is not sworn at trial, that'd be an error.
That would be an error. I'm not sure it'd be a significant error when,
You don't think it'd be reversible error if the witnesses at trial aren't sworn?
if it wasn't objected to,
Yeah.
I don't think it would be. Depending on the circumstances, I guess, but generally I don't think it would be.
You might have to agree to disagree on that. I think generally it's taken as a given that witnesses are placed under oath before they testify for the state in a criminal trial.
Well, they are, certainly.
Yeah, it's not an optional part of the procedure. And I guess the question is, in my mind, wasn't the prosecutor here a critical witness for the state effectively in the Poole hearing?
Right, and
Any difference?
well, the prosecutor did volunteer to testify, and again, if appellant would have requested that to be under oath, I'm not sure if that happened. I don't think it did. It might be a different situation, but I don't think it's fundamental error not to place the prosecutor under oath. Which kind of brings me to the third claim, the alleged misconduct in the third trial. Opposing counsel appears talking about the importance of the oath, but that's kind of the main complaint in the last trial, is that the prosecutor was comparing the victim's testimony, which was under oath, to his testimony that was given to the police, which was not under oath. But all the prosecutor was doing is basically pointing out that you have two different types of evidence, one under oath and one quick and not under oath.
When there are only two witnesses, and you're saying, in essence, implying, and the defendant never testified under oath, so therefore you weigh that against the victim's testimony under oath, that could be a problem.
Well,
And you've only cited, I think, one out-of-state case where that occurred.
well, opposing counsel, I don't think, has cited any cases basically indicating that a prosecutor can't bring to the juror's attention an obvious fact that the victim did testify under oath, and the jurors saw that. They also saw that the evidence or the statement from the defendant just came in without any oath and was a statement from the police.
There's an ironic parallel between this discussion and the one we had about 60 seconds ago.
I agree.
Okay.
And all the prosecutor's doing was comparing and contrasting. These are two different types of evidence, as the court kind of agrees as far as the prosecutor goes. Also, the jurors were instructed that the prosecutor's statements, the attorney's statements, were not evidence, and they were instructed that the defendant need not testify, that his failure to testify cannot be used against him. So presumed to follow his instructions. Opposing counsel at trial did not object and basically perceived this as to be a comment on the defendant's right to remain silent. And if you read the entire closing argument, the prosecutor really is mostly talking about the victim's testimony and how she would still cross-examination. And this whole case was about the victim's credibility. Does the court have any other questions?
All right. Thank you.
you.
Okay, we will take this matter under advisement. Thank both counsel for their arguments, and we'll issue a written decision in due course. Please stand adjourned.
He did.